Angela Langlotz, trademark and business law attorney here with another episode of, what are we calling this? Maybe Trademark Bites, I don't know. But anyway, I go live every day to talk about intellectual property issues. And if you like this, please share it if you think others might find it interesting or useful. Today, I'm going to talk about copyright infringement. So here's the situation. Let's say that you paint a mural or a painting and somebody else likes it so much that they photograph it and they make that image of your creation into t-shirts and coffee mugs and posters, and they earn money selling it on the internet or wherever. Is that copyright infringement? Well, yes, it certainly is. And that person who stole your property and made money off of it is liable to you for copyright infringement. So when you make a copy of someone else's work, that's called a derivative work. Now, derivative works are protected by copyright law. So what is a derivative work? Well, it's anything that derives, right? Anything that derives from the original work. So a derivative work could be a foreign language translation of a novel or some other type of literary work. It could be a remix of a song. It could be an adaptation of a play into a movie. There's lots of ways to make derivative works. Maybe it's a photograph of a sculpture that you did. That's also a derivative work. So people who create these derivative works, these copies, are liable to the creator of the original work for copyright infringement if they didn't get permission from the holder of the copyright to create that work. The definition of derivative works is really, really broad. In fact, the statute says that it's any other form in which a work may be recast, transformed, or adapted. So it's really, really broad. So what remedies does a creator of a work have against people who make unauthorized copies of their works? Well, there's a couple different types of damages. You can get statutory damages if you've registered your work with the United States Copyright Office. If you didn't register your work, then you can get actual damages. So the reason why you want to register your work is because it gives you the option of either choosing statutory damages or actual damages. So you can pick and choose based on what you think might be bigger and what might get you more money. The statutory damages can be up to $150,000 per infringement for willful copyright infringement. If you opt to go for actual damages, then that person is liable, the infringer is liable to you for any profits that he or she made from copying your work, in essence, stealing your work. So, for example, if that person, let's say, made a copy, sold a bunch of mugs and t-shirts with your work on them and made $150,000, they would be liable to you for their gross profits. They actually have to prove any offset. Maybe they had expenses or, in producing the work that would offset those gross profits and they would come up with a net profit figure. Well, they have the burden of proof on those expenses that are offsetting the gross profit amount. Now, the important thing to realize is that you don't have to mean to copy somebody's work in order to be liable for copyright infringement. I like to say that copyright infringement is kind of like speeding. We don't ask. When the cop hands you the ticket, he doesn't ask, hey, do you know you were speeding? I mean, maybe he asks it, but he doesn't care if you knew or not. He says you were going over the speed limit. Here's your ticket. And if you want to argue about it, you can, take it to the judge. Copyright infringement is like that. We don't ask whether you intended to copy. We don't ask, did you remove the copyright symbol? Although if you did remove the copyright symbol, that might be evidence of willful infringement that would trigger, damages for willful infringement. So you have to be careful when you're using stuff that you find online. Make sure that you're actually allowed to use it. Maybe it has a Creative Commons license, or make sure that you contact the owner of the work and ask for permission to use it, right? So make sure that you don't tread on somebody else's toes when you create stuff on the internet or use other people's work. Make sure it has some kind of Creative Commons license. I'm Angela Langlotz, and you can find me online at TrademarkDoctor.net. If you go to my Facebook page, which is facebook.com/TrademarkDoctor, and like my page, you'll be notified every time I go live. If you like this video, share it. Send some love to other people and let them know about trademark law and intellectual property. It might help them out too. I'll see you tomorrow.